Good morning. Today's topic is mental element in tortious liability. In this class, we are discussing intention, motive, and malice. You know, in every tort, there is a violation of rights of another person. Violation may be due to deliberate intention or it may be due to negligence. Law says act itself creates no guilty mind. Then what is the purpose of the law? Purpose of the law is to punish the wrongdoer and protect the innocent person and prevent harm. If person did wrongful act without guilty mind, it is useless to punish him. So in criminal law, guilty mind is important element for punishing the man for crimes. Why person do wrongful act? There are three stages of human mind which has to be examined. They are motive, intention, and malice. Now we will discuss about intention. What is the intention? Intention is the state of mind to object or purpose for which the act is done. The wrongdoer has full knowledge of the consequences of his acts which he wants to achieve. Intention is divided into two parts, one immediate intention and ulterior intention. Intention is relevant in criminal and civil liability. Why intention is relevant in determining the question of criminal liability? Because act is the result of intention. Intention is the immediate act. Therefore, criminal law gives importance to intention only. For example, some people motive is to protect the cow from the slaughter. Court consider the people's intention and not motive. The removal of cow from the possession of the owner was bad in law. It is immediate act and they are guilty of offense. The law will judge a man by what he does. It is difficult to know the intention of the act and it can be determined by the conduct of the person. Now we will discuss some case laws. Gill versus Swan. The defendant flew in a balloon. Unfortunately, he has to embark on the garden of the plaintiff. The huge crowd entered the garden to witness him. As a result, his garden was damaged. The plaintiff sued the defendant for damages. The court held that defendant was liable. It was natural wish to see the person flying in the balloon. So due to the crowd, the garden was damaged. This could be foreseen by the consequences of his act by the defendant. Another case is Wilkinson versus Johnson. Defendant made a joke to the plaintiff that plaintiff's husband had broken his legs in an accident and she was admitted to hospital. She was shocked and got seriously ill. She sued the defendant for damages. The court held that intention is not an essential element, but he knew the natural and probable consequences of his act. Therefore, he is held liable. Next one, what you are discussing is motive. What is motive? It is a state of mind. Motive is a state of mind. Motive inspires man to do act, which may be good or bad. Intention in criminal law is always bad and evil. So motives are not relevant in criminal law. Why motives are not important in criminal liability? Prosecution must prove the wrongdoer's mens rea intention. Motive are not relevant in the criminal law. So, for example, Ashok steals money from Bharat. He steals the money to feed starving children. Feeding the starving children is his motive. Stealing money is his intention. Criminal law is not concerned with the good motives. Motives cannot justify the intention. Motives also irrelevant in the law of torts, because for good motives, if a person takes an illegal way, law doesn't excuse him. For example, plunder in the rich. A has a motive to help poor. To help poor, he plunders the rich. For good motive, he adopts an illegal way. Law does not excuse him. Law will punish A. So, where a person did a good thing and legally inspired by evil motives, law recognizes his legal acts and not evil motives. Where a person did a wrong thing, wrongful thing, or omission inspired by good motives, law does not recognize his good motives. Law punishes him for his wrongful act. Now we'll take up the case law. Mayor Bradford versus Pickles. Plaintiff Corporation had been getting water from adjoining land of the defendant at a higher level. What the defendant did, he dug a pond on his land, which diminished the water flowing into the land of plaintiff. Plaintiff claimed injunction to restrain the defendant from digging the ponds. Their contention was that the sole purpose was to injure the plaintiff, as they did not purchase his land at an exorbitant price. The House of Lords held that the defendant was not liable, even though done purposely, because he was exercising his lawful right. Malice. What is malice? Malice means evil intention. It means wrongful intention, recklessness, wickedness. It may be moral or physical. In malice, there must be some design and vengeance in the acts of the wrongdoer. It is a condition of mind which prompts a person to do a wrongful act willfully to the injury of another, or to do intentionally a wrongful act toward another without justification. There are two groups, one malice in law and malice in fact. What is malice in law? It means intentionally doing a wrongful act. It means ill will against a person. It means wrongful act done intentionally without any excuse. It means concurrence of the mind with a wrongful act done without just cause or excuse. For example, Ashok gives Basava, he is a stranger, a perfect blow likely to produce death. He gives the blow intentionally without any excuse. Ashok puts poison on fishery without knowing the owner. He did it intentionally. In this case, defendant knowing the encroachers, the plaintiff writes, defendant knows the consequences of his wrongful acts towards plaintiff. Defendant intends to cause harm or injury to the plaintiff. He designed to do the wrongful act. His acts are without reasonable and probable cause. Malice in fact. What is malice in fact? It is called actual malice, improper motives. Malice in fact is an act done with ill will towards an individual. It depends upon the motives. Motives is an ulterior reason for the act of the doer. For example, plundering the rich man to help the poor. A has to feed his starved children, steals money from the beast's purse. The court cannot consider his motives to feed his starved children. Court punishes for his wrongful act of stealing. So motive is irrelevant. For example, if a person does lawful acts and with bad motives, law does not punish him. If a person does an unlawful or wrongful act with good motives, law does not excuse him. So, malice in law and malice in fact, malice in is not essential to the maintenance of the action of tort. Malice is irrelevant in the law of torts. There are such as exception to the rule. They are generally malice in fact is irrelevant in law of tort. There are certain exceptions. Defamation on a privileged occasion, malicious prosecution, willful and malicious damage to property, maintenance of injurious falsehood about goods, slander, title, and malicious conspiracy. In all these cases, so malice in fact is relevant. Now, what is the difference between malice in fact and malice in law? Malice in fact is an act done with ill will towards an individual. For example, with ill will, he is poisoning the fisheries. Malice in law is an act done wrongfully without reasonable probable cause. Malice in fact depends upon motive. Malice in law depends upon knowledge. Malice in fact means ill will against a person. Malice in law means concurrence of mind with wrongful act done without just excuse. Thank you.